Good morning, everybody. Good morning. That about concludes my remarks, and I want to say thank you so much for having me here this morning. I think everyone probably has my handout, and I'm going to talk about some of the issues on there as briefly as I can, and then if you have any questions, real-life drama of what's going on today, be happy to talk about those kinds of things. First item is as is. It's a perennial kind of an issue in real estate. As is fine as far as it goes, but it's not the end of the story. As is a good way of avoiding responsibility if a seller doesn't want to pay for things and wants to sell the property without making corrections. It's not a way to avoid disclosure. It's not a way to avoid inspections. And if it's not handled right, it's a way of incurring liability. I like to say that this is an issue of the power of I don't know, because as is sometimes means that parties think that they don't have to make disclosures. So it's very simple to how to think of as is. As is means that you're not promising that the property is going to be in any particular kind of condition. But it's not ever a substitute for property disclosures or inspection obligations. And sometimes people get into trouble on the subject of negligent misrepresentation, sort of tied into as is. Negligent misrepresentation is a kind of claim where a seller or an agent makes a statement about a property. It's a positive statement. Most of disclosure we think of disclosing negative kinds of items. Negligent misrepresentation means that you say something positive about it. The roof is only 4 years old, or there's no termite problem, or there's something else that's a relatively positive item, but you don't really know that that's true. So maybe the buyer comes by, you show them the property, you show where the fence line is, or the buyer sees the fence line, I should say, and says, is that where the property line ends? And you say what? Yes, oh, definitely, because it has a metal fence, or yes, definitely, because that's the toe of a hill, or the middle of a hill. Many times there's no real answer that you can give. So the reason this is the power of I don't know is that I'm going to offer you a couple ideas on how to make your client happy that you've done exactly the right thing for them without putting yourself into liability by making a statement that you can't really back up. And the way you do that in many different things, title is a perfect example, because fence lines or property outline is an issue of title. You don't know, and I don't know, exactly where the property line is. The property line is wherever some engineer who developed the area 50 or 100 years ago drew on a map. So in the Los Angeles County Recorder's Office, there is a map that says that the property line is exactly 50 1/2 feet east of some marker. And no one in this room is going to go look that up, and the buyer and seller aren't going to go look that up. When you get a question like that, the way to deal with that, the best thing you can do is hand the problem to somebody else. And the somebody else in the case of a title issue is the title officer. When you get the prelim on every single property, the prelim has the name of a live human being at a title company, not just generic, here's the title company's 800 number. It's got an actual title officer on there who will be happy most of the time to get on the phone if you make an phone appointment with you and your client and the title officer, and that title officer, chances are, goes home to his or her significant other who has no idea what they do for a living, doesn't care, frustrated. And in my experience, title officers, like anyone else with some expertise, are usually happy to share their expertise. Make a phone appointment, have your client go through all the questions that they have, whether it's an issue of where the property line is, or whether there's a right of view easement over a neighboring property, whether there's a height limitation under the CC&Rs. Those are the tough kinds of questions that there are. Every subject in real estate, whether it's buildable, whether the next door property has problems, there's somebody around in the transaction that you can put your client in contact with. You can be the spirit guide and to your client to get perfectly accurate information. Key is it's not coming from you, because you can't give more information than you actually have. Second, I want to talk for a minute about titling, and specifically couples. and married couples or unmarried couples, and there are different. There are now more than one choice of what legally recognized couples there are in California. We have now had for at least 15 years in California something called domestic partnerships, besides married persons. I'm not talking about the political side of any of this. This is a personal choice, and whatever your views of any of that are have nothing whatsoever with to do with your professional responsibilities. I'm going to talk for a minute about the legal implications of being a couple, being an unmarried couple, being a opposite-sex couple or same-sex couple, married or domestic partnership. The consequence of being married, biggest consequence, is that you learn to use the term "yes, dear." But in addition to that, the consequence in California is we're a community property state. Community property means that earnings of either spouse are the joint property of both spouses, regardless of which spouse earns and regardless of which spouse is on title. So if one spouse is on title but bought property using community income, it's community property. The two places that this matters are death, that is, who gets the distribution of the property upon the death of one, and what happens in the event of a divorce. The judge in Superior Court will decide what the consequence is of community property. Basically, unless the husband and wife or a couple have an agreement that changes what I'm about to say, anything that either spouse gets in the way of earnings and anything you buy with that is community property. You can change that in a properly drafted prenuptial agreement, but unless you do that, basically through lawyers in order to have it be an enforceable valid agreement, if you don't do that, it's all community property. That's nothing new in the case of a married couple. But what is new for many people is that we have domestic partnerships in California for at least 15 years. Domestic partnerships are two individuals who register with the Secretary of State. It's a form that they send in. It's not a religious ceremony. So how you become a domestic partner is different from how you get married. There's no officiant. There's no religious person that makes you, okay, one moment you're not married, the next moment you are. It's you signing a paper with the state of California. There are two kinds of people that can be domestic partners in California. They can be same-sex couples in which both are over 18. And if you are a domestic partnership, that means any earnings of either one of them is community property. Anything you buy with those earnings are community property. And the second kind of couple is one male and one female, but one of those people has to be at least eligible for Social Security, old age, or survivor benefits. Two people 25, opposite sex, cannot become domestic partners in California. You can that's just the way it is. So once you are a domestic partnership, and it's far simpler to terminate a domestic partnership than it is a marriage. That can be done by filing papers with the Secretary of State, just like you form a domestic partnership in the same way. And once you have a domestic partnership, anything you take in the way of earnings, anything you buy with it, is community property. All the other consequences of being married are the same, exactly the same. Visitation rights in a hospital, right to make decisions about your domestic partner, medical care in an emergency kind of a situation. Every single thing under California law is the same for married couples as it is for domestic partnerships. Now, in the background, there's of course all the political stuff going through the courts about married or not married for same-sex couples. That has nothing to do with any of this. What I just said is the law. It's been the law for many years. It's not as hip and interesting as the stuff in the news, but this is the kind of nuts and bolts thing that you need to know, because it affects title, it affects who can mortgage property, affects rights of occupancy of property. Real quickly on rent control, rent stabilization. There are a handful of cities in Southern California that are rent-controlled cities. Those are the City of Los Angeles, Santa Monica, West Hollywood, Beverly Hills slightly, and Palm Springs. And each one of them has a different set of rules. And the way this matters is if you're selling a multi-residential duplex or higher property, the rent stabilization ordinance in each of those cities has a big effect on rents and on the ability to terminate a tenancy, even if the, let's say a one-year lease is terminated. You cannot just decide you're going to, if you're the landlord, that you're going to terminate the tenancy because you're not happy with the tenant. There are reasons under ordinances for each of those cities that are legal reasons for terminating a tenancy. Now, most of you are not doing property management, so it's not going to affect you in that way. It is going to affect you in the circumstance where you're selling a tenant-occupied property. That the fact that you're selling a property, let's say it's a fourplex, the fact that it's in escrow does not mean that you can terminate, or that the landlord can terminate the tenancy just because it's listed or just because it's in escrow or they're planning to sell. There are technical rules in each of these cities, and I can give you the contact information should you want any of that for all of those cities. There's a handful of cities in Southern California, as I mentioned. There's a slightly larger number of cities in Northern California, San Francisco, Oakland, and a couple of others. Most of the geographic area of the state of California is not covered by rent control or rent stabilization, but obviously the city of Los Angeles is a gigantic player in all of this. So if you are interested in more detailed information, I'd be happy to give you that. I'll give you very quickly what the maximum annual increases are in the cities around here. City of LA, currently this year the maximum increase is 3% on a unit or property that's subject to rent control. That's not every property. Anything that was built after '78 is not, even if it's an apartment house, is not covered by rent control. Even if it's before '78, if it's a single family residence, it's not covered by rent control. And there are various other reasons why some properties, even though they may have been built before '78, aren't covered by rent control. But the majority of pre-'78 duplex or higher is covered by rent control, both in terms of maximum rent increases and in terms of what reasons you can terminate a tenancy for. City of LA has a list of 10 legal reasons for terminating a tenancy. Some of those you don't need permission from the city ahead of time, some of them you do. I'm not going to cover all of that stuff today because it really offends me when people start snoozing off and falling asleep while I'm talking. But you need to know the fact that there's a lot of information you need to know if it applies. So if it applies, if you're selling a property that's rent controlled or that's subject to an ordinance that affects rights of termination of tenancies, you just need to know that you need to drill down and get the information that applies to that kind of circumstance. So even though a city may not be rent controlled, some cities have a separate ordinance for just cause for eviction. And again, it's not a political question. It's a question of you making correct decisions or your clients making proper choices and needing to know what they need to know. One of the things this ties into is estoppels, and the idea that when you're selling a property that's tenant occupied, the parties ought to be thinking about getting an estoppel from each tenant, or choosing not to do that. But an estoppel basically means a written statement from each tenant saying, I have 3 years left on my lease, my rent is so much a month, I have no right of, no option to extend or renew my lease, or I do, so that everybody's on the same page, the buyer and the seller are on the same page on exactly what there is. The fact that the seller may provide a lease doesn't mean that the seller necessarily provided the complete lease or the second amendment to the lease. So these are kinds of important things obviously when you're selling. In addition, even on a single family residence, you cannot assume that the property can be delivered vacant at the close of escrow. If you have a lease in place where a tenant has 4 months left on their lease, but they have a 1-year option to renew, the fact that the property is being sold doesn't mean that the seller can say, well, I'm the owner of the property, I get to terminate the tenancy. So this is an issue of sometimes maybe doing the Vulcan mind meld with your seller and getting them to figure out whether the property is subject to tenant rights. Tenant termination, even in cities where you do not have rent stabilization or rent control, if the tenant has been in place and is in a month-to-month tenancy and has been living in there for more than 12 months, the minimum amount of time a landlord has to give written notice of termination that complies with the California rules, it's just not any notice, the minimum amount of time is 60 days. A tenant needs to give a 30-day notice if they're on a month-to-month tenancy. Landlord needs to give a 60-day notice if they've been in there for more than a year. So City of LA is 3% currently, City of Santa Monica is 3.2%, but there's a maximum of a $52 monthly increase. West Hollywood has a 2.25% increase. Palm Springs has a 3/4 of current CPI increase. So you can't assume anything. You know, like the ad used to say, all aspirin is not alike. You just need to know, somebody needs to know or get correct information on all these things. Brief item about estate planning. The Congress periodically changes what the rules are on estate planning, on what you can pass through to the next generation or to friends and not have an estate tax kick in. Currently, the rules are that you can pass along $5 million worth of money or property or stocks or bonds or anything else, $5 million, plus you can leave an unlimited amount of property, stocks, bonds, etc., to your surviving spouse. Spouse means spouse. Under federal estate tax law, there's no such thing as domestic partners. There is either you are married or you are not married under federal tax law for this purpose. So starting January 1, 2013, the current $5 million rule is changing or expiring, and as of January 1, it will be $1 million, which means it's going to affect lots of different people. So again, it's a subject that has many, complications. You can you do many things well, and I'm sure no one in the room is also doing estate planning. It's just an informational item that you need to know, either for your family or for yourselves or for your clients, that that this is something that bears people getting to either the 1-900 number of the Psychic Friends Network, if that's how they want to do their planning. That's a joke. So if you want to, or get to an estate planner, a lawyer, or a proper estate planner. Finally, I want to mention very quickly dispute resolution. The majority of contracts that I see contain an arbitration clause. It's not a legal requirement to initial the arbitration clause. You can have buyer and seller initial it or not initial it. Whether arbitration is initialed or not, mediation applies automatically under the purchase agreement, or the CAR purchase agreement. Mediation is sort of a much lighter process than arbitration. It's like sitting around your parents' dining table and mom and dad try and get the kids to figure out how to get along. So in a mediation, you have a mediator sit around and try and get the parties to come to some kind of a resolution, and usually it works. If you manage to get the sides to a mediation, whatever it is, between buyer and seller or landlord and tenant or two agents with a dispute, if you get them to the table, most of the time it works out. They sign a new agreement, says this is how we're going to work out our disagreement, and then that's an enforceable settlement. They don't have to reach an agreement. If they don't, then the next step is either a lawsuit or an arbitration. If the arbitration clause of the purchase agreement is initialed, then the parties are obligated to go and arbitrate. Arbitration means that you have a private person, usually it's one, it can be three arbitrators, but typically it's one, And that arbitrator is like a private judge, has the power of life and death over the dispute. So that the parties present their sides. It's like Judge Judy on TV. Judge Judy can decide either party is right or either party is wrong or neither party is right. It's typically it's a faster process than a lawsuit is, and it's a cheaper process than a lawsuit is. And if you have friends, or perhaps you, or lawyers that you've talked to, who either very much like arbitration or very much don't like arbitration, usually that's a function of whether they won or they lost. If they lost, then they're convinced that that the system was stacked against them and they didn't get an even count. And if they won, then arbitration is a real efficient way to resolve disputes. The message for your clients is it's a personal decision. You can't jam arbitration down their throat. If one of them doesn't want to agree to arbitrate ahead of time, then the key is that whichever way it's going to be, either initialed or not initialed, should be the same for both parties. The buyer initials the arbitration clause, and the seller says, no, I don't want to do that, then that's a counter item. So just counter it out, and that's okay. It's perfectly fine, perfectly legal not to have an arbitration clause. Now, litigation is a longer process. There's no minimum or maximum amount of time. Typically, it's much more expensive. The last item I have in the outline you can see is if all else fails, pistols at dawn. You know, you can just pick a convenient site and, you know, walk from 300 paces and turn and fire. Hopefully, you're going to be able to keep your clients under control better than that. So, what can I answer? Global warming, I have no opinion, but otherwise, almost anything.
When an investor buys a bank-owned property and they take possession with the past owner, do they qualify as a tenant at that point?
Question is, can everybody hear the question? No. Question is, it's an REO property. The buyer buys the property and assumes the problem of vacating whoever's in there because the bank sells it as is, including whoever's in possession. The question is, what kind of a notice do you have to give to the person living in the house or unit as to termination? The answer used to be that, and it still is for an owner, technically, that if it's the owner that is living in there, you have to give a 3-day notice to quit, and then you follow that up with an unlawful detainer, which is an eviction lawsuit. But the federal law changed about 2009, and there's something called the Protecting Tenants at Foreclosure Act, which says that if you have a tenant, you have to give at least 90 days notice in the case where you have a month-to-month tenancy. You have to give the tenant at least a 90-day notice, and the reality is if you buy the property, you don't know who's living in there, and you also don't know who they're going to claim is living in there. So the practical answer is that the buyer may well decide, this is a buyer choice in conjunction with their own lawyer, but it's typically you're going to decide in favor of giving the 90-day notice to everyone that's living in there, because otherwise you have no way of knowing when you probably have not seen the inside of the unit during escrow, and you don't know how many people are living in there. They may be tenants, they may not be. Now, in addition to that, under the federal act, if the tenant has a bona fide lease in place that has an unexpired term, they have the right to stay there for the remainder of the unexpired term as long as they continue paying rent under the terms of the lease, and as long as the lease payments, the rent, is not unreasonably low, which is sort of like saying it's got to be fair market rent, but not quite. That's what the federal act says. So you have to assume, I would assume 90 days notice. Once the foreclosure is finished and I own the property, 90-day notice, and then followed by an unlawful detainer. Anyone want to tell jokes? One up there. Marilyn Barnett.
Yes, sir. How would you explain liquidated damages to the client if they ask your opinion whether you should initial them or not?
Liquidated damages, what I would explain is that you're agreeing ahead of time on how much money the seller ends up keeping if the buyer breaches. But the important thing about this is that's not to say that because a sale doesn't close, the seller gets to keep money. Because if the seller doesn't close because of some contingency or because a disclosure was given by the seller and the buyer disapproved a TDS or any other contingency right, liquidated damages clause never really kicks in. The buyer has a cancellation right. If they timely cancel, disapprove and cancel, then liquidated damages doesn't have anything to do with it. Liquidated damages means that you're agreeing on how much the damages will be, money damages that the seller gets to keep if the buyer breaches their contract. So.
Do we have any obligation to determine whether a person is in a domestic partnership? Is it our responsibility to ask, or are we supposed to mention that or pass the buck?
If the person's a seller or a buyer or what? Let's say. If the person, well, the place that this really lands is title. And escrow, either escrow or title is going to furnish, usually escrow, to the buyer a confidential information statement or statement of information. In every escrow you get an SI to fill out all this information about where have you lived, who have you been married to. The newer forms say, are you in a domestic partnership? If you were in one, has it been terminated? So it's a title issue really, both on the sale side and on the buy side. Because on the sale side, the title company is responsible if there are more than one person that really needs to sign a deed, but they don't. So in order to figure their job out, you need a statement of information. In fact, the purchase agreement now says that the seller will furnish a statement of information early on in the transaction, and it's for that kind of a reason. It's not your job to figure all that stuff out, but your clients will ask you about it anyway. Yes, sir?
A domestic partnership, is that canceled by a form, or is that like a divorce?
It depends on whether they get along. Well, so to speak. I mean, obviously, things could be better when you're terminating the relationship. You're not getting along. Some people are going to be able to figure it out, just like in divorces. If you're in a divorce, it's the same thing. That the smarter move is to follow Danny DeVito's advice from The War of the Roses. For anybody who ever saw that movie, where he starts off this by saying, look, if at the end of what I'm about to tell you, you still want to go forward with a divorce, figure out how to give your soon-to-be ex-loved one whatever he/she wants and move along with your life. Don't fight over all of this. Some people can do that, and some people cannot. Divorces, whether they are of marriages or domestic partnerships, dissolutions, I should say, they're called dissolutions. If you can work it out with a mediator, a family law mediator, you're far better off doing that, working out, who gets the pets, who gets the plants, who gets the money. Then if you do that, you can terminate it by filing with the Secretary of State. You can also file in the Superior Court a dissolution action. A domestic partnership is handled in the family law department, the divorce department, if you will, of the Superior Court. And that covers everything because it's pension rights, it's who owns the apartment building, it's who is entitled to the kids. Domestic partnerships, frequently there's a kid or more involved that may have been adopted, or there may be visitation rights even if there's not an adoption. It's it's much more complicated than when Ozzie and Harriet were running, the whole show.
Okay, so there's a public notice. My concern was like, with a divorce, you can find records that a divorce has been the solution unless it's sealed. With a domestic partnership, it's not one of those things where they kept it in a deep, dark secret, and then 10 years later, somebody comes back and goes, we were domestic partners at that time, but we just didn't feel right about telling the world that now that he sold my $1 million property, I want to have it.
Well, the fact that you're a domestic partnership is a public record if somebody goes and checks the Secretary of State, but nobody I mean, you can't do that online.